Hello friends, welcome to our class. Now we are going to start class notes of Polity Vision IAS class 7. It requires a special majority of the parliament and also the consent of the more than the half of a state legislative assembly with a simple majority. Subject that can be amended under this type manner of election of the president, matters relating to the executive power of the union and state, representation of the states in parliament, matters related to the Supreme Court and High Courts, distribution of the legislative powers between the union and state, any list in the seventh schedule. Provision of the Articles 368 relating to the procedure for the amendment of the Constitution. These all are related to the federal provisions. The criticism against the amendment process. There is no special body for or institution to amend the constitution. In the US, it has a special body. Only Parliament is given the power to the amend the constitution. Most of the time, constitution was the amend mostly for the political purpose. A state legislature cannot be initiate the amendment process which goes against the federal nature for the constitution. The state legislature can only initiate the process of establishing a legislative council or the removing existing council. Even here also the recommendation of the state legislature are not binding on parliament. There is no time limit for the state legislative assembly to give the approval. There is no provision for the joint sitting of the House in case of a deadlock between the Lok Sabha and Rajya Sabha. Constitution. Article 1 of the Constitution. Article 1 and 1 to 4 under the Part 1 of the Constitution deal with Union and its territory. Article 1 describe India. Example Bharat as a union of a state, not a federation of a state. Our constitutional forefathers discussed in the depth the status of the country. They felt that India can't afford the classic federation like the USA. In the USA, all the states had come together in the voluntary manner and they created the federation. Entry into the federation was the completely voluntary in nature. Citizens also have dual identities. Example, they are the citizen of the state as well as the country. In the USA, every state has its own driving license. The residual power which are not the mentioned in the constitution are given to the state. There is called a classic federation. There uh, where the state have more autonomy. States are the mentioned in the name of the country also. And entirely into the entry into the federation is the voluntary, but leaving the federation is Government of India Act 1935 Act has for the first time the introduced federal form of the government in the India. It is a weak federation with the central government retaining power over the defense, international relation, currency, and the international security. The princely estates were given complete freedom in the all the other matter, but this the experiment was not as successful as most of the princely estate refused to the join the federation. After independence, our constitutional forefather had many challenges confronting them while the formulating to the constitution. This biggest problem was how to the protect and the preserve the unity and integrity of the nation. The country was also facing problem related to a partition of the country on the communal lines, b integration of the 640 princely estate into the Indian Union, c successionist tendency in different part of the country, d the idea of India was a very young. By the taking all the problems into the consideration, it was the decided that India would be a union of state only and not a federation. India is the described as an the in instructable union of the destructible state. States have been the created only for administrative efficiency, and they do not have only the political identities. The country is described as a union, although the constitution is the federal in nature. Dr. B.R. Ambedkar explained the reason for the adopting the union of state instead of the federation of state. In India, our federation is not a result of agreement between the state. Unlike the USA, similarly, states also do not have any right to the secede from union. According to the Article 1, the territory of India is the classified into three categories. First, a territory of a state, B, a territory of the union territory, C, a territory which may be acquired or government of India any point in time. At present, there are 28 states and 8 union territories. Territory of India is the much wider expression than the Union of India. The Union of India includes only the states, whereas the Territory of India includes UTs and also the other territories that India might be acquired in the future. Now the territories can be the acquired according to the modes recognized by the international law. A. Cession through the treaty, purchase, gift, lease, and or though publicized. B. Occupation, land which the occupied. C. Through the conquest. India has acquired the several territory after independence: Dadar, Nagar Haveli, Goa, Daman and Diu, and Puducherry and Sikkim. Article B. The Parliament may be law admit into the Union or establish new state on such terms and the condition as it India's fit. Article 2. Parliament has the power to admit new state into the Union, to establish new state. It means the admission of the already existing states, and it also has the power to the create a new state where not exist before. Article 3. The Parliament has the power to form new states and the alternation of the areas, boundaries, or the names of the existing state. It can create a new state by the separating of the territories from an existing state. For example, Uttarakhand from the Uttar Pradesh, Bihar, and Jharkhand, Andhra Pradesh, and the Telangana, or by the unity two or the more state, or by the uniting any territory to a part of the state. Parliament can increase the area of the state, it can decrease the area of state, it can change the boundaries of any state, it can change the name of the state also. Under Article 3, the bill must be satisfied two conditions: a shall it shall be introduced in the either house of parliament only on the recommendation of the president; b the bill must be the referred by the president to the state legislature to express. It gives the president can fix the time limit for the state legislature to express its view, but the view expressed by the state legislature are not binding on the president. Article differences between 2 and 3. Article 2 relates to the admission or establishment of new states that are not part of the Union of India. Article 3 deals with the internal readjustment of the territories within the Union of the India. Constituent Assembly or the Article 3 explanation. Dr. B.R. Ambedkar argued giving the absolute power to Parliament for the creation of the alternation of boundaries of a state is against the spirit of the federalism. Most of the members agreed on the anti-federal nature of the Article 3, but it was the necessary. Why? The princely estate and the secessionist tendency. Example, in 2011, the UP Assembly passed the resolution to the divide UP into four parts, but it was not accepted by the center. Example, in 2014, the Andhra Pradesh Assembly rejected the resolution to create Telangana, but the center went to ahead with the creation of the state. If the power is given the states, it will be lead to separatist, as secessionist tendency, regionalism and terrorism. Article 4 of the Constitution. Article 4 provides for the procedures for the establishment of the new state. It also the mentioned the procedure will not be the considered as the amendment to the constitution under Article 368. It means that these laws can be the passed by the a simple majority and by the ordinary legislative process. The powers of the parliament to the determines the area of state. Article 3 does not include the power seized the India territory to the foreign country. The question had come up to 1960 before Supreme Court through the presidential residence. The government decided to cede the part of the treaty known as the Berubari Union in the West Bengal and Pakistan in 1960. Supreme Court ruled that can be done only through the constitutional amendment under the Article 368. Finally, the Ninth Constitutional Amendment Act was passed by the Parliament to transfer the Treaty of the Pakistan. In 2015, the 100th Constitutional Amendment Act was passed to the given effect to the questions of the certain territories from Bangladesh and the transfer of the some other territories of the Bangladesh as the part of the setting long-term border dispute with the Bangladesh. Evolution states in the India explanation. At the time of the independence, the British India plus princely state reorganization of state took place over the time. Initially, the Constituent Assembly and the Congress Party against the further reorganization of states. When the freedom movement was going to simultaneously, regional movement was also going on. The Madras provinces or Telugu speaking people, 16 districts formed as a separate committee and they meet the Mahatma Gandhi and ask for separate identities. After independence, the separate statehood demanded grow further. Dhar Commission rejected the idea of reorganization based on language. Uh, rather than a recommendation to create the state based on the administrative efficiency. JP JBC committee constituted Pandit Jawaharlal Nehru, Vallabhbhai Patel, and Pottabi Sitaramaiah. Potti Sri Mallu went to the hunger strike. Andhra Pradesh come into existence based on the linguistic lines. It ignited agitation in the different parts of the country. 1953 Fazal Ali Commission, it recommended the linguistic reorganization. The Mysore states Kerala, Tamil Nadu was the formed. In 1960, the Mahatma Gandhi Gujarat come into existence from the Bombay provinces. 1960, the Punjab was the divided into Punjab and Haryana. Chandigarh was the made the combined capital. Sikkim was the brought into the Union Territory. More states were created in northeast. Goa was the made a state. Mysore became the Karnataka. 2000, the Jharkhand, Uttarakhand, and Chhattisgarh were created. It stated the debate in Andhra Pradesh from the further division. History of the Andhra Pradesh and Telangana. Telangana region was the ruled by the Nizams. It was the backward, whereas coastal Andhra was the ruled by the Britishers. Britishers created more dams and brought more land into the cultivation. So coastal Andhra was more developed. So in 1960, agitation started in Telangana for the separation from Andhra Pradesh. In 1967, Indira Gandhi made the P.B. Narasimha Rao as the Chief Minister of Andhra Pradesh. Thus, the agitation did out temporarily, and now the people of the Andhra started agitation for the separate state. In 1960, India adopted the LPG and the Hyderabad, Chennai, and the Bengaluru. The witnesses huge development because the South software hub. In the 2000, the government created the three states Uttarakhand, Uttar Pradesh, Jharkhand, and Chhattisgarh. The demand for the separate state Telangana against started. The common in the all news start created. All were the facing the issue of the being backward and for the from the capital. 2009, the UPA government decided to the divide the state. Thank you. Thank you very much.